Hello, I'm Professor Theo Myrie with the University of Washington School of Law, and this is the Introduction to American Law lecture on contracts. So let's talk contracts. All right, so contracts as an area of law we can actually call private law. And what we mean by private law is it's really the various laws, either statutory under something like the Uniform Commercial Code as between businesses, or under common law, which is the practices between private individuals. So you and me, basically. So what we've got under private law then is a lot of legal principles that govern how we interact with each other when we make agreements, and specifically when those agreements go wrong. All right, so let's talk about what a contract is. All right, one thing to keep in mind is there is a lot of vocabulary for contract law, and so there are many terms of art which may be confusing if you've never heard them before or never used them before. So there is, to some degree, an interchangeability, which means the words can be used almost in the same way, between contract and agreement. All right, so usually I'll be talking about contracts, but sometimes I'll use the word agreements, and so these mean basically the same thing. But let's take a look at a more technical definition. All right, this is an archaic one, which means kind of an old-fashioned way of saying it, that a contract is a promise or a set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes as a duty. All right, so we need to translate this into sort of contemporary plain English. And one of the ways of doing that is to think of the promise or set of promises as being a promise that you will do something or you'll refrain from doing something that you have a right to do. All right, so you actually make this kind of promise. Now, if you break your promise, then that's called breach. All right, that's a contract breach. So anyone who breaks their promise under an agreement has breached the contract. And this is very interesting because the other side, right, the other party to the contract, the other person in the agreement, they have a right to enforce the agreement if you break it, right? Or if you break it and they can't get it enforced, there can be some other legal remedy for them. And a remedy is really a solution to the problem when there's been some kind of harm or damage done. All right, which is to say, if you break your agreement with somebody, or they break their agreement with you, and there's a loss or harm or damage, then we need a remedy. We need a solution for that. And so these things in combination give us an old-fashioned way of looking at what is an enforceable agreement. All right, there are elements to a contract, and so many agreements do not necessarily rise to the level of a contract. For a contract to be enforceable, we need to make sure that both parties to the contract, both people in the agreement, actually are agreeing to the same thing. They're actually understanding what they're agreeing to at the moment that they enter into the agreement. So meeting of the minds is the way of discussing this, and that's very important. All right, so make sure that whenever you're looking at whether a contract exists or not, that the parties have the same understanding of the agreement going into the contract. Now, aside from that, in order for a contract to be formed, we need three basic things. We need an offer, and we need acceptance, and we need something called consideration. All right, and consideration is not being polite. Consideration actually means sort of the exchange of something valuable. All right, so let's we're going to come back to that prior slide, but let's take an old example of the elements of a contract. All right. Although marriage is not a contract, or rather I should say it's no longer a contract, the traditions we have around becoming engaged actually embody all of the elements of the contract we just discussed. All right, so here's a pop sonnet for single ladies, right? Better put a ring on it. And what we've got, other than for the Beyonce fans out there, what we've got is actually an example of offer, acceptance, and consideration. So in an engagement, one party makes an offer, right? Will you marry me? And the other party may accept that offer. Yes, I will. And then what is the thing of value exchanged? The engagement ring. This is the thing of value that you then give to the person who has accepted your offer, right? And that those are the elements of a contract, right? This is a very easy way to memorize that. All right, so now let's go back to this slide. All right, for the formation of a contract, offer, acceptance, and consideration can be complicated, right? Each one of these elements can become unstable or not work properly, and if one of them fails, then you don't have an enforceable legal agreement. There's not an enforceable contract sitting there. So let's look at this. All right. As far as offer is concerned, the Lefkowitz case from our readings addresses this. And the basic scenario is an advertising scenario. Right? So this is, way back in the day. It's an old case. But in common law systems like ours, old cases can be just as valid today as they were when they originally were issued by a court. So the Lefkowitz case is we've got an early department store, and the department store is having a sale on furs. And so we've got a member of the public who sees an advertisement for that sale, and it's the sort of on a first come, first served basis, right? So they go to the department store, they wait until it opens, they go inside, and they try and buy the fur coat for a very low amount of money, as the advertisement said. The store refused to sell it to the buyer because it was a women's fur coat, and it was a man who was buying the fur coat. And so they said no. And so he tried it again, and they said no. And it ended up in court. And the court basically said, look, when the department store makes that offer and the buyer sees that offer and comes to the store to produce acceptance of that, the seller cannot revoke the offer once the acceptance is in place. And so the advertisement itself set the terms for the offer, right? So if you've ever wondered when you go to a store or something like that, if you've got a coupon or something like that, that actually is embodying the terms of their offer. And when you go to buy it and you show them the coupon, you're actually showing your acceptance, right? And that means that their offer was a valid offer. Okay, so let's go to acceptance with the Vergellement case. Actually, one question that will come up with students from time to time, if we go back to the Lefkowitz case, is what's the consideration? The payment of the amount for the fur coat is the consideration for it. So the offer is the advertisement, the acceptance is the showing up, being the first in line. The consideration is the monetary exchange for it. Okay, so now to Vergellement. All right, so Vergellement it's an extremely famous case, and it's actually very famous in restaurant circles. So if anybody likes food and going to restaurant, this case is for you. But it's a fascinating sort of case. So here you have a situation where the entire legal debate in this case is on what is chicken. Right, this is a case about chicken and the different kinds of chicken. So a restaurant needs chicken for its dishes and for service, and the restaurant actually ends up ordering from a meat export company a whole lot of chicken. All right, but the question is the quality of the chicken. All right, so the restaurant wanted chicken that it could actually serve for its main courses. What the seller provided was chicken of a sort of a lower, tougher quality that you would use for stews and things like this. And so the restaurant said, "This is not what we ordered." So they returned it, and then at a later time, a similar sort of thing happened with them. And then the seller basically said, "You actually have to pay for all of this, and these chickens, they're yours." And the buyer said, "Well, wait, this is not what we ordered, so we don't accept your offer of these chickens." So the court has to look into the agreement between the parties to figure out exactly what was promised. All right, what did the seller of the chickens promise to the restaurant? And what they decided is that the requirements in the contract fit easily either description of the good chicken for fancy dishes for the restaurant, or the older, tougher, bigger chicken that is good for boiling but not for these other recipes. And since the contract didn't specify the exact kind of chicken, it just had these other ways of talking about the chicken, and what the seller provided fit that description. There was in fact acceptance by the buyer of the seller's offer, so it became an enforceable contract, and the buyer had to pay, right, for the chicken. All right, the consideration element here is fascinating. I love this case. This case is hilarious from a historical standpoint, especially by contemporary standards. But in the Hemmer v. Sidway case, the debate that the court is having is whether there was sufficient value exchanged between the parties for the mutual promises. So here's what the promise was. An uncle turns to his nephew, and the nephew is going off to college. And the uncle said, "Look, if you behave well, right, refrain from drinking and smoking and swearing and cavorting with people, right, then I will give you this amount of money. So I'll reward you for good behavior when you go to university." So the nephew went off to school and behaved quite well by all accounts, and then approached the uncle and said, "All right, I refrained from smoking and drinking and gambling and cavorting and doing all of these bad things. I was a good person with good behavior, and so now I would like my money, please." And the uncle simply laughed and said, "Oh, no, this wasn't actually like a contract agreement. I was just doing this for your own good, so that you'd be a moral and upstanding person." The nephew, however, did not like this answer and took his uncle to court. All right, and that's how this case emerged. So the court had to figure out whether we have an enforceable agreement here, and this is basically what the court said. Look, when the uncle said this, it might have been, as the uncle argued, for the betterment of the nephew, to give the nephew a stronger moral character, to make them more of an upstanding person, to make sure that they're better equipped to be a good student, to perform well without the distractions of dissolution and all that sort of thing. And so the uncle got no benefit from the contract. This is sort of what they're arguing. This is really just for the benefit of the nephew. And if the uncle's not getting a benefit, then what is the mutual exchange of promises here, right? What is the mutual exchange of value? And so the court said, look, the nephew, however, had a right to do all of those things, right? When you go off to college, you have a right to swear. You have a right to drink, to gamble, to cavort, to do whatever it is that you want to do that is not studying school. So the court said, look, when the nephew refrained from doing these things, the nephew actually gave up those rights, and that has value. And even if the uncle can't really utilize that value, that was sufficient consideration for the contract. All right, so the promise of money to refrain from these actions, right, meant a mutual exchange of value. And so it was an enforceable contract. That is how the court decided that case. So we will in our Zoom discussion class, we'll actually discuss these cases in a little more detail, particularly for Guillemot, but we'll come back to these. Okay. So now let's talk about the kinds of contracts that are out there. There are a lot of different kinds of contracts, and you're going to have a ton of terms of art. So here is a slide with terms of art galore. All right, there are void contracts, voidable contracts, unenforceable contracts, express oral contracts, implied contracts, bilateral contracts, unilateral contracts, adhesion contracts, quasi-contracts, executed contracts, and executory contracts. All right, so let's just work our way through the list. A void contract means the contract was fatally flawed from the very beginning and never became an actual contract. All right, so one of the ways to think about this is an illegal contract. All right, there are some contracts that we just can't have. Right, so you can't have a contract to break the law. All right, so let's see, what can we do? Let's talk Hollywood for a second. All right, so in all the action thriller movies where an assassin has been hired, the assassin is being paid to go and assassinate somebody. Right, so think of a mafia movie of some kind. This would normally look like an agreement, right? There's a promise, right? I will pay you X if you do Y. There's an acceptance, all right? I will do Y if you pay me X. And there can be consideration. They actually assassinate someone, they actually get payment. All right, but what if something goes wrong, right? So what if the person who hired the assassin then refuses to pay? All right, so can the assassin go to court and say this is an enforceable contract, like in Hammer v. Sidway, and get their money for that? And the answer is no, right? That is a void contract for a variety of reasons, mostly for violation of public policy. But illegal contracts are void contracts. Now, voidable contracts are contracts that look like they were valid contracts when they were made, but there's such a sufficient or substantial defect in the contract that the contract can be viewed at a later date as not being valid. All right, so what might be a good example there? Well, okay. So this is gonna bleed into unenforceable contracts. So let's move to unenforceable contracts. So in an unenforceable contract, you might have a situation where you've got a void or voidable contract, right? And what you're looking at is once there's been a breach of the agreement and you go to court, can the court actually enforce the contract or award a remedy for the breach of the contract? And so an unenforceable contract would be one that can't be enforced in that way. There can be a number of things that create an unenforceable contract. For example, in a lack of capacity scenario. So capacity means you have the legal ability to do something. And I think virtually everybody in the class will have a cell phone of some kind, probably a smartphone of some kind. Along with the smartphone usually comes a carrier agreement, right, like with AT&T or Sprint or something like that. And that agreement, you'll sign it. You'll have like a 1-year contract or 2-year contract or something like that. You'll get the cell phone, and you agree to pay these fees and amounts of money. All right, but what if somebody who is a minor, and by that I mean somebody under the age of 18, comes along and gets a cell phone contract? And the answer is that this becomes an unenforceable contract because a person under the age of 18 does not have the capacity to enter into a contract, right? And this is why people's parents are the ones who sign the contract with AT&T or Sprint or any other telecommunications company, not the minor. All right, not the minor. Now, this can have complications in criminal law in a different context, but that would be an unenforceable contract. All right, so express or oral contracts. These are contracts where the terms of the agreements are actually said to each other. All right, either in writing or verbally. So here's something that's very, very important to know. And a lot of people are very confused by this. A contract or an agreement can be either written or verbal. Okay? An oral contract is still an enforceable contract. Right? It's just as enforceable as a written contract is. Now, there's a variation on statutes of limitations. An oral contract that gets breached, you have 3 years to bring legal action about that contract, and usually when it's a written contract, you have up to 5 years to bring it. So there are some slight differences on your window of opportunity to get a remedy for breach of contract. But an agreement itself that's written or directly stated between people, right? That's the express or oral contract. An implied contract is an agreement that the court will, almost as a legal fiction, create. They will construct a contract based on the behavior of the parties. If the parties are behaving as if there were an offer, acceptance, and consideration, right, a mutual exchange of value, even though they didn't write it down or directly say it to each other, their behavior can create all of the elements of a contract. And if the court sees that, they will create an implied contract. All right. The next kind of variations on a contract we want to think about are bilateral and unilateral contracts. So this is, to some degree, what we look at when we're talking about how the parties are engaging with each other in the formation of a contract. Right? A bilateral contract is where both parties are exchanging promises, right? And the acceptance and consideration is there. They're both active participants in what's happening. Hence bilateral, right? Bi meaning two. So this is opposed to a unilateral contract where one party is engaged in the contracting process, but the other party is sort of in an express way. But the other party isn't responding in words or in writing. Instead, what they're doing is they're responding with their behavior, with action. So in the next slide, we'll take a look at an example of this. But this is where one party basically says, "Look, if you do such and such, I'll give you this." The other party does not verbally respond or respond in writing, but instead they do the thing that was asked of them. All right, that might create a unilateral contract. Right, now there's something called an adhesion contract, which we all experience, but most people don't know that that's what it is. An adhesion contract is where there is actually a huge difference, right, in the sort of power levels between the negotiating parties. I think, well, let's just talk Facebook, for example. When any sort of major internet company has a terms of service, right, that you have to click on, Apple can be this way also, and you accept them, this is an adhesion contract, right? You have not negotiated any of the terms of that agreement. They simply have put all the terms out there, and then you have accepted those terms, all right? And that's an adhesion contract. Other examples of adhesion contracts, airline tickets are this way. Really, tickets on any common carrier are this way, like buses, things like that. The internet agreements on like privacy and terms of use are that way. Often when you're looking at digital downloads of any kind, they'll have a thing you have to click that actually creates an adhesion contract. Credit card agreements are this way also, as are things like your cell phone agreements. All right, they may look like adhesion contracts. So there are a lot of terms in there that you didn't specifically negotiate with or for, but you are now agreeing to abide by. All right, now there's something called a quasi-contract, and this is, think of this a little bit like an implied contract, but it's really based on the level of performance. Okay, so let's look at the word performance for a moment. Performance is when you've made a promise to do something or refrain from doing something under the agreement, and that's exactly what you did. right? You fulfilled that promise. That's called performance. So what happens in a quasi-contract, think of this in like a construction setting, or with things that involve manual labor, because it arises in that context a lot. So somebody says, "Hey, I need this thing built, or I need my like a fence built, or I need my garden cleaned, or I need a deck built, or something like that." A person agrees to do that, and they begin construction. They're sort of halfway through, and then the person who hired them comes out and said, "Well, actually, we need to stop here. So don't finish the gardening. Don't finish the fence. I don't want it done, or I don't have money to get it finished, or something like that." Well, once they've performed a certain amount of work, now it's not all complete, right? The fence was not fully built, or the yard was not fully gardened, or something like that. But they've done a substantial amount of it. They're actually entitled to compensation for the work that they've done, and that's called quantum meruit. It's a Latin phrase. There's a lot of Latin in law in the terms of art that we use. So quantum meruit basically means you get paid for the value of the work that you actually did, even when the contract is not complete. All right, and that's a quasi-contract. Now, there's also something called an executed contract or an executory contract. Now, here's a different way of using the word execute. All right, under the law, to execute, you may think of it in terms of like capital punishment, where somebody is subject to the death penalty, and they're executed by the government. But what we actually mean in contract law by execution is signatures. So when you execute a contract, you sign the contract, right? So an executed agreement is an agreement where the parties have signed it, so it's signed and dated, right? An executory contract is a little different, so don't let the name throw you off. An executory contract is where the contract is underway and both parties still have duties, the promises that they made, right, that to be performed. They still have to do some of the things they promised under the contract. Think Amazon. All right, so you order an item on Amazon, you pay for that item, and then the item is being shipped to you. During that process of shipping, when you've not received the item that you've paid for, you actually have an executory contract going. All right, and so those are the different sorts of contracts that you generally need to know about. So if we're talking about foundational legal literacy and contract law, this page gives you a lot of the key kinds of contracts, variations that you need to be aware of. All right, so now let's look at an example of a unilateral contract. So there are suspension bridges. A lot of people in the Pacific Northwest love to hike. They get out in nature. They find rope bridges, all sorts of things. And if you were walking in nature and you see one of these things, and people often go out in pairs or in groups of friends. Let's say one person turns to the other person and says, "Hey, you see that old bridge out there, that rope suspension bridge?" And the other person says, "Yes, I see it." And he says, "I'll tell you what. I will give you $100 if you will run across that bridge." All right, the other person takes a look at the bridge, and without responding to the person who made the offer, they in fact run across the bridge, right? And then they come back and they say, "All right, give me my $100." Right? Our first question we're going to have is, do we have a contract? Right? Do we have a contract? Was there offer, acceptance, and consideration? All right, so in that sort of situation, the offer was made by one person. All right, run across the bridge, I'll give you $100. The consideration is also that $100. Where did the acceptance go? The acceptance is actually in the running across the bridge. So rather than expressly agreeing, the person performed their duty under the contract. So this makes it a unilateral contract because one person expressed themselves, the other person did not. All right, so it was not a bilateral agreement. If it was a bilateral contract, then when the person said, "You run across and I'll give you $100," and the other person says, "Oh, hell yeah," and then they run across, that would be a bilateral agreement. All right, does that make sense? Right, so these are different ways of thinking about it just applied. And again, we'll go over some scenarios in the discussion session. All right, now, once a contract is breached, right, somebody has broken their agreement with somebody else, we have to take a look at contract remedies, which is how to solve the problems that arise from breaking the agreement, from breaching the contract. So, as we saw from the original definition of a legal contract, right, we need the promises, the breach of which, right, provides a remedy. And so, or the courts can provide a remedy for the breaking of that agreement. So here's contract remedies. So when somebody has broken their agreement, often monetary damages are possible under most contracts. All right. So, but monetary damages are not all the same. There are different kinds of monetary damages, which means you pay money for breaking the agreement. There are expectation damages, there are consequential damages, there are nominal damages, liquidated damages, and as we saw, quantum meruit damages. All right, and those are the sort of monetary damages that are there. So expectation damages are very interesting. So when people enter an agreement, both people are looking, right, in the meeting of their minds, they are looking to get the benefit of the agreement. So people enter into agreements because they mutually benefit from them. So the expectation damages are a kind of damage that says, look, when one party breaches the agreement, the other party should get the benefit of the agreement. They should get what they expected from the agreement, and that's expectation damages. All right. Consequential damages are a kind of damage that's a little similar to a series of unfortunate events. If anyone's ever read that book series or watched the videos of it, the series of unfortunate events basically are this: when one party breaks their agreement, the breaking of that agreement causes a chain reaction of bad things to happen. All right, and the cost of those bad things, right, they can be held responsible for if their breach is what caused or approximately caused it. So we'll talk about causation, approximate causation, when we're in the tort section more. But this means there's some kind of a causal connection, like dominoes, right? This was the first domino that started the chain reaction. So consequential damages, you need to have a causal link, is what we call it. So there's causation from the breach to the chain reaction of bad things that happen, and that chain reaction needs to be reasonably foreseeable. All right, at the time of contracting. So the person needs to, the breaching party, they need to be able to understand that if they breached it in this way, these bad things might happen. All right, so there are a whole number of scenarios that this can apply to. The very famous one is Hadley v. Baxendale out of Great Britain from a long time ago. This is where a mechanical piece breaks. Because it's broken, there's a loss of production, there's a loss of transportation, there's a loss of benefiting from the sale of all of those goods. All of these consequences happened because this piece broke down and the new piece couldn't get there on time. So in this intermediate period, lots of things had to be, sort of damages had to be sustained. And the breaching party would be responsible for those damages. Nominal damages are damages where somebody, the court actually says, yes, somebody breached the contract, but the value of that breach is very, very low. So you get a legal victory, but you really do not get much of an award or a remedy from it at all. So nominal damages are a technical win, but not a substantive one. Right, liquidated damages are disfavored in law, which means courts really don't like to see them, because what the parties in an agreement have done is they basically said, look, if we look into the future and we say there are all kinds of things that can go wrong in this contract, and if something goes wrong, we're not going to figure out what the expectation was. We're not going to figure out what the possible consequences are, and we're not going to, make it a nominal victory where it's a technical win, but you don't get anything of value. Instead, we're just going to set a price and say if there's a breach of contract, this is the amount of money that the breaching party has to give to the other party. And that's liquidated damages. So businesses can find these exceptionally efficient. All right. The courts don't like them because they don't take reality into account. They don't look at the actual damages suffered by the parties, and they don't look at all of the different parts of the context that can have an influence on that. So courts don't like them, which is to say judges don't like them, but businesses do. So liquidated damages clauses make their way into contracts, particularly between businesses, quite a lot. Right? Quantum meruit we discussed, right? This is when you've done some of the work and you're entitled to the value of that work, even if the whole contract is now going to be stopped. All right. There is a concept lurking about in contract remedies called a duty to mitigate. All right. And what they're talking about is to mitigate harm. And mitigate means to make something less bad than it could be. So for instance, if you had rented a car and you told the rental company, look, I've got to get to the airport by this time because I have a flight to Hong Kong. And in Hong Kong at the airport, there is a large meeting and I'm going to be receiving an award of some kind. And this award has a huge monetary value to it. So I need the car to be reliable and to get me there on time. They give you a car, it breaks down on the way to the airport. You can't actually just sit in the broken car and let the loss of the airline ticket, the loss of receiving the award, the loss of getting the recognition and the money from the award, all of that. You can't just have those losses accumulate. You have to mitigate the harm, right? Which means probably calling a taxi, right? Or calling the company and seeing if they can help solve the problem, like sending you another car right away. Right, give them notice of the problem that's happening. So there's a chance to fix it. So there's a lot that can kind of go on here, but the duty to mitigate harm is always present in an agreement, which raises another thing that contracts have in them. So let's talk history for a second. A very old-fashioned word for a promise is called a covenant. All right, a covenant is and it still is used in faith traditions in many religions. A covenant is a concept that people may recognize from there, but it's actually here a legal term. And a covenant is a promise to do something or refrain from doing something. There is in every contract an implied covenant. All right, which means there's an implied term in that contract, and it means the people don't have to have agreed to it. Society places it inside every contract, and it's a covenant of good faith and fair dealing. And it means that the people are not acting, in bad faith with each other. They're not acting in a deceptive way. They're not acting in a fraudulent way of some kind. They're actually engaging in the agreement in good faith, which means they're wanting the agreement to be there for their mutual benefit, right? And fair dealing, they treat each other fairly, all right? So one example might be, say, collectibles. So if there's a collectible object, so let's say that there is... let's reach back to people's childhoods. Let's say that there's a very valuable Pokemon card, right? And you go into a store and you see this very valuable Pokemon card, and it's worth $10,000. It's a very expensive Pokemon card. I don't even know what creature it could be, but let's say there's a $10,000 original print Pokemon card, all right? And you're like, wow, I'd really love to have it for sentimental purposes, but I don't have $10,000 in cash spare. And the next week you're at a garage sale. You're walking through your neighborhood and somebody is moving and they have lots of things out for sale, and there's a box of Pokemon cards, and you're looking through the box, and here is that original card, and the box says all cards 50 cents each. All right, so you take that card, you buy it for 50 cents, and you're incredibly happy because you look like you've got all the elements of a contract. You have a garage sale offering these things for 50 cents. You take the card, you pay your 50 cents, right? You've got offer, acceptance, and consideration. Looks like a great contract. But if you know this card is super, super valuable, and the other person doesn't know it's that valuable, and you have this sort of superior knowledge, if you hide this fact from them and they find out about it later, they may come to you and ask you to give the card back. All right, because this is a really unfair situation. So good faith, and they would claim you have violated the duty of good faith and fair dealing. You had superior knowledge, you kept it to yourself, and you allowed the agreement to move forward. Now, other people would say, no, there really is an enforceable contract here. So the other side might say, well, in addition to violating the duty of good faith and fair dealing, there's a fundamental mistake. The seller did not understand the nature and value of the card. All right, and so mistake might be a way to show that there is no valid agreement there. Right, so the scenario raises lots of different legal debates. This is something you should be aware of, right? There are, in any given situation, a lot of different legal theories that might apply as to whether you have an agreement, whether the agreement is valid and enforceable. If it is enforceable, are there defenses? If somebody says, oh, you've breached the agreement, can you say, no, I didn't, and here's why? When you say, no, I didn't, and here's why, do they get defenses to defenses and say, well, actually, that's not right either, like a tennis game going back and forth, right? So contract law has all of these embedded in it, and we're basically learning the terms of it here. All right, now, other remedies are things like restitution. All right, restitution is a strange phrase, or strange word, but you all recognize it. The basic legal concept of restitution is to put the party in the position they were at the beginning of the contract. All right, so the restitution for us, we've all experienced it if you've ever gone to a store and asked for a refund. A refund is restitution. All right, I bought this item for this amount of money. For whatever reason, it doesn't work. I'm now returning the item. I would like you to restore my purchase price to me. That is restitution. That puts you in the position you were in, or the parties in the position they were in, at the very beginning, right? At the very beginning. So expectation damages, right, as the sort of polar opposite of this, is putting a party in the position they would be in if the contract were fully performed, right? If all the things people promised to do had been done. So restitution is at the beginning instead. Rescission is an interesting remedy, and rescission, maybe you can think of the root word in there like scissors, right? And rescission means you actually sort of take the contract back, or you cut the contract up, right? Rescission, or to rescind a contract, means that that contract is going away. All right, and sometimes rescission is the solution, like in the Pokemon card case. If the court agreed with the yard sale or garage sale seller, then that contract might have been rescinded, and you'd have to restore the card, and so restitution might be the solution in that case. All right, reformation of a contract is an interesting remedy, and reformation of a contract means you're actually going to reform the contract based on the behavior of the parties, so that you do have an enforceable agreement of some kind. All right, and so oftentimes the behavior of the parties can cause lots of confusions. There may be minor breaches of an agreement. There may be variations in performance. Right? There may be changes in circumstances for what can be expected from the contract, and so the court has the ability of reforming the contract to comply with behavior of the parties and changes in conditions or expectations. All right, specific performance is the last kind of remedy, and it's rare as a remedy. The reason it's rare as a remedy is specific performance generally applies to unique circumstances. All right, and the reason it applies to unique circumstances is that courts will enforce a contract through specific performance by making the parties perform the agreement. All right. Now, normally in private law, like the law of contracts, parties can breach a contract if they're willing to suffer the consequences for that. Right? If I break my agreement, then I may have to pay you expectation damages. I may have to pay you consequential damages. I may have to refund your money, right? Do restitution, something like this. Specific performance means I now have to perform the agreement, right? I don't get the option of breaching it. And so courts don't do that very often. You have to have a pretty unique set of circumstances to make that happen. Sometimes one of the more common places we can see specific performance arise is where the thing itself is rare or unique, such as the purchase of a piece of artwork, right, or the purchase of a piece of real estate. Every piece of property is unique. They're not all the same. Right, the land is different, the house is different, the design is different, the age, condition, right, all of these things are kind of unique. So with these sorts of objects, if you have a purchase and sale agreement, sometimes specific performance is what is required by a court as a remedy, which is the solution to the problem. Okay, so key contract terms. So as promised, there are a huge number of terms of art in contracts, and here are some that you need to be aware of. Revocation. All right, revocation is where in a contract the parties want to take it back. All right, and that's called revoking a contract, where you want to take the contract back. So an earlier example, for instance, in the building of a fence for your yard, if you stop the project, that's called canceling the contract, right? And you may attempt to revoke the contract as if there had been no agreement. But the person building the fence, if they've done some of it, right, they may have a quantum meruit claim as a remedy for a breach of contract. All right, so can you revoke a contract? Yes. Are there defenses to that? Yes, maybe. Are there solutions to that? Maybe quantum meruit, something like that. Novation is a really interesting contract idea. So a novation is where people who have had an agreement and the agreement has gone wrong, they decide that they're going to change the agreement, the terms of the agreement, right, the mutual promises and things like that, but they're going to keep the basic agreement intact. So they form a new agreement. All right, they form a new agreement. So the old agreement goes away, the new agreement takes its place. It's kind of like a substitute agreement. That's called novation. Now, keep in mind, novation has to have all the elements of a contract, right? Offer, acceptance, and consideration. Performance is a key term, and I referred to that earlier. Performance is where the party has actually performed their duty under the contract. All right, so for instance, in the Amazon scenario, Amazon has offered an item for sale, you have accepted their offer, you have paid them money for it via the credit card on the account, and they have delivered the item to you. All right, you have performed, they have performed. All right, and then that is a fully performed contract. All right, reliance is an important concept in contract law. Reliance is where somebody, based on the promise made to them, behaves in a certain way, all right, or does something in a certain way. So, for instance, let's see, we could think of event planning here. All right, so in event planning, somebody may want to put on a birthday party or something like that. And they rent a space for the evening to do that, and then they buy a cake, they get presents, they go to a rental store, and they get tables and chairs. All right, so let's say that the people who have rented the space for the birthday party, let's say they cancel at the last minute, but the person, in reliance on that space being available for the amount of money that they paid, they've already rented the tables and chairs. They've already ordered the food. They've already ordered the cake. They're relying on that contract. All right. So if the people who own the hall breach the contract, they may be liable for the consequential damages, right, based on the other person's reliance on the contract. This applies in a lot of scenarios. So reliance is a really important idea. It will also come back in something called equity or equitable remedies. So we really look to see whether somebody has relied on the promises made, and if they have relied, if they have either performed their part of the contract or they have taken other actions by relying on the promises made of a contract, then oftentimes the courts will try and figure out a solution to this in a way that doesn't look like there's no agreement at all. They'll actually try and figure out a remedy. All right, breach of performance is where you break your promise in the agreements. Notice is something I referred to a little earlier in the example of the car breaking down. So notice means when the other side has breached their agreement, right? When their performance is defective, that's one of the ways of phrasing it. When they haven't done what they said they would do or they did it badly, you can give them notice of the breach. You say, hey, look, you're not doing what you're supposed to be doing under the contract. So here's your notice for that. Please fix it. All right? Please fix your performance to comply with the agreement, with the terms of the contract. So the other side then has the ability to fix their performance, right? Send you a car that actually works, right? Or make an alternate arrangement to get you to the airport. They rent a limo or a taxi or an Uber or something like that. All right, so that would be cure. If they then fix the problem with their performance, that's called a cure. All right, this is actually going to relate, I'm going to jump down the list a little bit, to warranties. All right, warranties are a promise that something will work the way it is supposed to work. So for its sort of usual purpose. Let's see. Let's think something like a space heater. All right. So let's say we're coming into winter. Everybody is studying for university classes very hard. You're doing your homework, but the room you're in is very cold, so you want a heater in that room. So you buy a space heater. Along with the space heater comes a list of terms and warranties, right? And what the warranty means is the manufacturer is actually promising you explicitly that this heater is going to work for the exact purpose that you bought it for, which is to heat the space that you're in. All right, so the space heater then comes with this warranty for performance. If the space heater, you turn it on and it doesn't heat the space, you can actually do two things. You could go back to the store and try and get restitution, which is a refund, or you can actually contact the manufacturer and you say, look, your item doesn't work. All right, you have breached your warranty. They will now say, thank you for the notice. Give us an opportunity to cure. So send us the space heater. We will fix it and send it back to you, and then it will work. Okay, so that's how warranties operate, right? That's how warranties operate. Warranties actually embody this idea that there can be notice of defect and the ability to cure, and that they will cure it, right? They will cure it. So that's how those ideas all relate to each other. Conditions to a contract are where you use the word if in a contract. All right, so let's do it like this. All right, so let's go back to the bridge scenario. All right, for a moment. All right, there's this bridge. It's hanging there, and I say, all right, look, you run across that bridge and back, and I will give you $100. Okay. You look at the bridge and you say, okay, it's missing some boards. It looks a little rickety, but I think I can do this. right? But this is what you say to yourself. You don't say it to me. And you run across the bridge, and more boards break. And on the way back, you hit a place that you just can't jump over. Okay, that you just can't jump over. So now you can't make it back. All right? You can't make it back. Now, my agreement with you is that if, right, which is to say on the condition that you run across and back, then I will give you this amount of money. All right, right now we've got a unilateral contract because I promised that. You haven't said anything back. You've run across, so you've tried to perform, but your performance was interrupted because you couldn't get back. Do I owe you the $100? All right, do I owe you the $100? Our answer might be no, because of the condition. All right, the condition was if you run there and back. Now, could you say in your defense, but I've partially performed, I ran there and came back a little bit, can't I get quantum merit? Aren't I entitled to a little bit of it? All right, so this would be a debate. That's a legal fight to figure out whether or not any money is owed at all. But that's an interaction between different contract ideas. All right, modification is very important. So people make agreements all the time, and people change their agreements all the time. Modification is the contract idea that allows you to change an existing agreement. All right. If you modify a contract, and this is the difference between novation and modification. Novation means you're getting rid of the old contract and putting a new agreement into place. All right, modification means you're keeping the old contract and you're changing it in some way. You're adding to it, you're altering some of the agreements already there, right? There's a modification that takes place. And you can do that. You still have an enforceable agreement, but the modification itself has to have all of the elements of a contract. There has to be offer, acceptance, and consideration. All right, and if you do that, then you have a validly modified agreement, right? So people can change their agreements, which we call modifying, and modifying can add to an agreement or change an agreement or take things away from an agreement, but it has to comply with the basic elements of contract formation. All right, mistake we talked about, where one or both parties completely does not understand material facts, right, that affect the substance of the contract, and that can render a contract unenforceable, or provisions under a contract unenforceable. It could lead to rescission or cancellation. It could lead to any number of things. All right, so mistake is something to be aware of. And then promissory estoppel is the last idea. So let's talk promissory estoppel. All right. I have mentioned equity or equitable, which is basically fairness in a situation. The law wants things to be fair. All right. It's a systems policy built into a lot of our interactions around contracts and property law. Promissory estoppel is an idea that if you say a contract exists and the other side denies that a contract exists, promissory estoppel then is a defense to the denial, right? And it says, look, based on the behavior of the parties, what we've done, right, the performance of it, the promises of it, the consideration of it, it would be unfair if you were able to deny any agreement exists at all. All right, so promissory estoppel is a defense to a defense, right? So I say there's a contract that exists and you have breached it. You say no contracts exist, so you couldn't have breached it. And I say, wait a minute, based on our behavior, it would be unfair for you to deny there's a contract. So I'm going to use promissory estoppel to stop you from denying the contract. All right, we may still have to work out whether you breached it or not, but you can't deny any contract or agreement exists. So there are requirements for this, right? We need a legal relationship that exists between the parties, and a contract can establish that. But we need some sort of legal relationship that exists. We need a promise between the parties that the injured party, right, can actually show some reliance towards, right, that they're actually relying on that promise. And then when they relied on that, something happened to their detriment. All right. So in the events planning scenario, when you got food for the party, got a cake for the party, you rented furniture for the party, you're in reliance on an agreement to rent a room for a birthday party. Okay, and if the agreement were to go away, then your reliance is to your detriment. You now have food and a cake and tables and chairs that you have no place to use them for. Okay, so now you've paid out this money and you have these things, and that's to your detriment. That's a negative for you. And then we've got unconscionability as sort of the last element of this. It's unfair of the promiser to break their promise. So if the place that had agreed to rent you the room for the birthday party, if they were to break their promise, that would be unfair of them to do so. Then but they deny there's any contract. So let's say that the way you got this room was you were socializing with friends at a safe distance of 10 feet without masks, or 6 feet with masks, and in your socializing you said, hey, my significant other is having a birthday, I want to do this party. They said, that's great, I actually have this spare room or office or space that would be great for a party. You should use it for your thing. And you say, great, I will. Here's when the party is. They say, wonderful. So you can use this. A question might be whether or not a contract exists. And we know that contracts can be either written or verbal. So this might be an oral agreement between people. But if the person says, look, I never made an agreement with you to actually rent the room. I just said you can use it, right? Or I said you might be able to use it. It was conditional. Maybe I didn't tell you what the conditions were. So we really didn't have an agreement, right? Maybe that's what they're saying. It was just conversation over a drink or coffee or just while passing. Not an actual agreement. So you might be able to use promissory estoppel to prevent them, but we would have to inquire into those facts. Okay, so that brings us to this question. All right, if people make an agreement with each other and it's a verbal agreement, an oral agreement with each other, that can be an enforceable agreement, but we need to have evidence to prove the agreement exists. How do we do that? All right, how do we do that? So there are a variety of things that we need to take a look at. So there's something called a statute of frauds. There's something called the four corners of a contract. There's something called parole evidence. There's something called the contracts rule. There's something called party performance. There's unjust enrichment, and there's conduct of the parties. So let's talk about this for a second. So the statute of frauds is a very, very old sort of governmental policy and embodied or encoded into a statute. And the statute of frauds basically says when something is valuable enough, it can't be subject to an oral agreement. You have to write it down. Okay? You have to write it down. So property is this way. Usually anything that's above a certain amount of money, and the money can change over time, right? It could be $500 at one point in history. It could be $5,000 at another point of history. But we're basically looking at the statute of frauds that says, by statute, what the amount is, and that if it's over that amount, we need to have it in writing. The four corners of a contract basically says this. Look, when parties have entered an agreement, we need to know exactly what is contained in that agreement. All right? The best evidence of this is the agreement itself. If the written contract does not have that term in it, that promise in it, then the court will not allow that to be enforceable. It has to be contained in the four corners of the agreement itself. All right, so think a lease agreement. All right, everybody in our class who has entered into a lease agreement of some kind or a rental agreement of some kind That document itself, right, is going to contain all the terms of the agreement, and it's not written there. It's not part of the context. Part of the contract. Now, we do have something that is kind of a conflict, and this is a conflict that exists between jurisdictions. All right, so most civil code countries do not allow for something called the context rule to come into play. All right, and the contracts rule also relies on parole evidence. So here is the basic idea. When we've got a written agreement and we're looking to how the parties understand that agreement, what the meeting of their minds happens to be, can we look to things outside of the contract? All right. If we can't look to how the parties have discussed it, right? So this might be in the emails that led to an agreement, in the voice messages that led to an agreement, into the first, second, and third versions of the agreement before they finally got to their final agreement where they signed it, right? If we can't look to that, then we're excluding all of the conversation about the contract from how we interpret the agreement. But if we can look at those things, if we can look at the context of it, then we can use the context rule, right? So, and the context rule actually helps us interpret or the meeting of the minds, which is to say, when the parties are both looking at a contract and they're having different interpretations. Think the Frugalamon case, what is chicken? One party thinks that chicken is a certain kind of chicken, older, larger, tougher, and the other party thinks that chicken is a much more delicious kind of chicken, younger, smaller, more tender. All right, but all that's contained in the contract is the weight of the chicken amount. Then what do we do? How do we understand what is actually contained in the agreement? So a context rule would allow us to look outside of the four corners of the agreement, right? And sometimes we can only do that when there's an ambiguity in the contract, and an ambiguity is where a term of the contract can be subject to two or more reasonable interpretations. All right, and then in jurisdictions that allow a context rule, we can go outside the agreement to figure out what the parties might have meant, which is to say, when their minds met, right, what were they thinking? And we use exterior evidence to do that. Sometimes you have an agreement that's evidence when a party actually performs it. Unilateral contracts, the running across the bridge, that is performance, and that helps to give evidence that an agreement exists, particularly for oral agreements. Unjust enrichment of a party. This is where you actually look to see what the benefit of the agreement was. All right, if one party has so benefited from the agreement that their benefit is enormous compared to the other party, then this party might have unjustly been enriched by the agreement. Think the Pokemon card, right? And unjust enrichment tends to tell us that's not fair, right? That in an equitable sense, that's just not good faith and fair dealing. That looks like one party has benefited extraordinarily at the cost or expense of the other party. That's unjust enrichment. That actually will maybe be evidence that an agreement exists, or it may be evidence that an agreement should be changed or modified by the court, or a remedy should be different in a different way. A better example of unjust enrichment, think of it like this. Where let's see. Let's go back to construction for a second. Okay, so or maybe to something like The Amazing Race. All right, so let's say that there's a race. And the other person says, "Look, I have $1 million sitting here in this huge jar. All right, and if you can reach, let's pick a destination. Let's say Vienna. If you can reach Vienna by noon on Saturday, right, which is, let's say that's 24 hours away, then you can have this $1,000,000. And if you don't reach Vienna by noon on Saturday in 24 hours, then not only do you not get the $1,000,000, but you're going to have to pay me $500,000. All right, so the other party says, yes, I'll do this. Now, this might be a gambling contract, which is unenforceable as an illegal contract under many jurisdictions, but let's say this is the setup for sake of argument. The other party, so you try and go, all right? And but before you go, the other party says, look, I've got my $1,000,000 in a jar. You need to put your $500,000 in this jar, okay? In that jar sitting right next to it. And if you don't make it, then I get this jar, right? And you try and go, but your plane is canceled due to COVID-19 restrictions. All right, there's too many people, or something has gone wrong in the airplane or with the ventilation system, so you can't get there. And the other party says, well, you didn't make it, so now I get the $500,000. You say, that's ridiculous. That is unjust enrichment. I didn't fail to go to Vienna because I didn't try. I tried to perform, but some exterior circumstance caused me to not be able to make it, right? And in law, we call that force majeure, right? Or an act of nature has done it, like COVID-19. So the question becomes, does the person get to keep the $500,000 or not? All right, so if gambling is legal in this jurisdiction and this contract might be enforceable, the question is, can it be? And so one of the things that might be here is that if the contract exists and that person receives that amount of money, isn't that unjust enrichment given the circumstances that made the performance of the contract impossible? All right, so unjust enrichment can work in a variety of ways. It can show a contract is there. It can show that a contract should not be enforced. It can show that the extreme benefit of one party over the other party causes a problem in terms of remedies, right? And how we view the contract as being valid and enforceable, or as what the proper remedy might be. So unjust enrichment is a very interesting question, and we look to a lot of different evidence in the situation. All right, conduct of the parties. Agreements can always be shown by how parties behave towards each other. If parties behave towards each other as if an agreement exists, we might have evidence of the agreement. This is frequently the case where there was an original agreement between the parties, but the agreement was performed. People did everything that they said they were going to do under the contract, so the contract is done now. And then the parties just sort of keep behaving as if an agreement still exists. They keep buying things and sending to the other person, selling things and sending them to the other person, right? They keep exchanging things of value that look like the original agreement, but the original agreement expired. So we might say their behavior evidences a new agreement, right? That's there. Okay, that is actually the end of the contracts lecture. There are so many scenarios that we can explore or examine using contract law and contract theory. And we're going to do some of that on Thursday so that we have facility, we learn how to use these ideas, both for contract formation, for contract remedies, contract defenses, variations on things. So it'll be fun. This will be a fun chat, largely because human beings make agreements and break agreements with each other all the time. So until Thursday, good luck and stay healthy. Bye for now.